Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I'm very excited to have attorney Jim Sorenson. He is a partner at Sorenson Van Leuven Law Firm, and we are going to be talking about what we usually talk about, which are credit unions. Today it's going to be about debt collection rule and other recent activity of the CFPB. And I want to welcome you today, Jim. Thank you so much for joining us.
Thank you, Erica, for having me. Looking forward to talking with you today.
So, talking about the CFPB, it seems like an important agency for credit unions and banks to monitor. Is that an accurate statement, Jim?
Yes, it is. The CFPB, or more appropriately, our accurate name, the Consumer Financial Protection Bureau, is a very important federal agency. It hasn't been around that long, but it is has significant power and oversight over banking regulations, banking laws that impact the services that the financial services that credit unions and banks offer to their customers. And ever since it's come into existence, it has significantly impacted how my clients have to operate. So it is a big player in the market and something that has to be watched on a regular basis, and something we do at our law firm.
Well, that sounds really important. There has been some recent news on the CFPB and a recent Supreme Court case. Can you tell us a little bit about this case?
I can, as you know, this case may have been lost with some of the other Supreme Court cases. The Supreme Court has been issuing a lot of rulings recently, but this was a significant case. And this case had to do with a challenge to the constitutional structure of the CFPB. It had to do with the underlying law. When Congress created the CFPB, they wanted it to be an independent agency. They wanted it to be this consumer watchdog that looked out for the little guy. And part of what Congress wanted to establish was an insulation of its director so that the president could not fire him or her, the director. And there was a constitutional challenge to that, whether the president had power to fire an agency head. Could Congress create this law to prevent that firing? And this legal challenge has been going on for years. This has been in the works for years. And the Supreme Court just ruled on this and did find that part of the CFPB structure was unconstitutional. In other words, under the Constitution, there's a separation of powers. If you go back to your civics classes, we have the executive branch, the judicial branch, and the legislative branch. And so the CFPB is part of the executive branch. And the Supreme Court found that insulating the director from the president's ability to remove him or her was unconstitutional. And instead of striking down the CFPB and saying the whole thing had to be thrown out, started over, they just struck down the portion of the law that protected the director. So now that director can be replaced by the president, just like any other agency head, and that's really the crux of the case, or the decision that the Supreme Court decided this past week.
Wow, that sounds like they are really going to shake things up. So, I guess getting down to brass tacks, what is the impact that this decision is going to have on the CFPB going forward?
Well, there's probably two impacts. I mean, one, obviously, the president will be able to change the direction of the agency. So in the upcoming election, if Joe Biden wins, more than likely Joe Biden's going to replace the current director of the CFPB, and the CFPB could go in a different direction than what it has been since the current director has been put in place by President Trump. If President Trump wins the election, then obviously there wouldn't be a change there. The more significant thing to watch is part of this court's decision, and the court left this question unanswered, was, well, if the director's position was unconstitutional, then did all the actions of the prior directors, i.e., all the rules and regulations that the agency has issued, are those rules and regulations proper? Are they enforceable, or are they subject to challenge? And the Supreme Court didn't address that issue. And one of the issues that comes up is an issue of ratification, and or if the agency has to readopt all those regulations. The CFPB kind of tried to head that off earlier this week. On Tuesday, the 7th, the CFPB issued an official notice of ratification saying, we hereby ratify all the prior acts of the former directors in the former regulations, trying to head off that litigation. It remains to be seen whether that's enough. And it's something we're going to have to watch. But for now, the rules and the regulations of the agency still stand. So not all the questions have been answered, but for now, the rules continue to have to be followed in our, for all effective purposes, the law, until a court says otherwise.
Oh my gosh, that sounds like that is going to be a real mess later on if they decide that whatever the past director did was not constitutional, and then it's going to just open up Pandora's box, and you're going to have a lot of people going back to court to try to have their decisions overturned. I mean, is that what you're saying could happen?
Yes, that's what I'm saying. And then, you know, it leaves in doubt what is the applicable rule. And, you know, for a business, one of the worst things you can have is uncertainty as to what the rules are. It's one thing to have a hard rule to comply with. It's another thing to not know which rule you have to comply with. And so that's the potential uncertainty that's out there. We'll have to wait and see how it plays out. But the CFPB is taking the position, we have now corrected the issue by ratifying all the rules and regulations. And like I said, we're going to have to see, does the court agree with that or not?
Wow, that's very interesting. It's great that you're updating us on this, and I'm glad that all of your clients have you to help guide them through major changes like this in the industry. So what has the CFPB been up to lately?
Well, lately they've been doing several things, actually. They've been fairly active over the last several months, even with COVID-19 and the pandemic that's going on. One of the things that they've done related to COVID-19 is that they've been providing some guidance, both to consumers. One of the things this agency does is it provides guidance to consumers. So if a consumer is having an issue with a creditor or with a loan or financial product, you can go to their website and get information. So there's a lot of new content that they've released related to COVID-19 that is guidance for consumers, to educate consumers, to provide them information and to help them protect their rights. But they're also doing that with the regulated industries, the industries they regulate. In the case of my clients, the financial institutions, the credit unions, there's been guidance there as well for our credit union clients. So that's part of what they've done. They've also recently issued some rules, or some proposed rules. They've issued just this week, they issued a proposed rule on small dollar lending. These are what are commonly referred to as payday loans. This is a proposed rule, so it isn't final yet. There's also a proposed rule on escrow exemptions to what are called high-priced mortgages. And they issued earlier, I believe it was back in May, interim rule on loss mitigation options for homeowners recovering from this pandemic. So it was some additional guidance to the industry, the mortgage industry, on how to deal with helping homeowners who are struggling during this guidance. And on top of that, they continue to pursue bad actors. There has been numerous news releases from the agency or from the Bureau about certain bad actors they've gone after. These are usually scams or schemes that are set up to try to trap maybe people who are maybe uneducated or unsophisticated, or maybe just caught in a bad situation, and they get caught in these scams. Some of these, most recent one was a company that supposedly would help you negotiate and get out of your student loans. And CFPB took action against that agency, finding that they were engaging in illegal activity. So those are some of the things that they've been up to lately.
I mean, that totally makes sense, because I mean, even if you go bankrupt, you're not allowed to get out of your student loans. So yeah, that's great that they're able to handle that. Now, do they usually handle consumer complaints regarding financial services? And what has been happening in that area?
Yes, they do. They are the number one agency for consumer complaints regarding financial services and products. And according to the CFPB and the information they release, April and May, I haven't seen anything on June yet released, but April and May have been their highest or most active months for complaints. The volume of complaints by consumers has been highest in those 2 months than any other months. What's interesting, the most common issue in the complaints is mortgage loans. So people complaining about their mortgage lender. And then the second most common complaint was a tie between credit card lenders and then just credit reporting in general. In other words, people complaining that a creditor or a credit reporting agency was reporting inaccurate information about their credit. So those are the top items that are being reported to the CFPB by consumers, and obviously those are areas of focus and concern for the CFPB.
So that's really interesting, and I'm glad that you're bringing all of this up and really clarifying. Now, did the CFPB issue proposed debt collection rule last year, and what's been happening to that rule?
Yes, last May of 2019, the CFPB issued a proposed rule, and as I mentioned before, they've issued recently some new proposed rules. This is how these federal agencies work. They're required under federal law to generally issue a proposed rule. There's a comment period where the public can respond to the rule. Typically, the people who respond to the rule are people who are interested in whatever the rule regulates. And then at the end of the comment period, typically the agency will move forward and issue a final rule. In this case, the original proposed rule was issued, like I said, May of 2019. And then the comment period ran into, it was sometime into the fall of last year. And then several months went by without any activity on the rule, at least any public activity. And then in March of this year, they issued an interim additional supplement to the proposed rule. So they looked at some of the initial comments and I guess decided there were some additional things they wanted to add to the rule. And basically that supplement addressed what is called time-barred debts. Those are debts that are outside the statute of limitations. So these are old debts that a creditor never sued on, never got a judgment. They could be, 8, 9, 10 years old. And so that's what that portion of the rule was dealing with. Since then, the CFPB has not taken any further action until on June 30th, in an announcement that they make about upcoming rule activity. They did indicate that their plan was to move forward with a final rule in October of 2020. So that's where it stands now. We expect there to be a final rule on the debt collection rule come October of 2020.
Wow. I can't believe so many things have been happening just over the summer, even during this pandemic. I guess it's great that things are still in motion, but it makes things, pretty exciting in your industry.
It does. You can't take time off. There's still a lot happening out there that we are trying to stay on top of and keep our clients informed of.
Well, they're lucky to have you. I say it all the time. So do we know what will be in the final debt collection rule that's released in October?
Not really. I mean, we can certainly make some educated guesses based on the interim rule, but one of the things that is going to be interesting to watch is what exactly the CFPB does, because when the proposed rule was released, there were a lot of consumer protection groups, consumer protection advocates that felt like the CFPB did not act aggressive enough to protect consumers. They did not go far enough to protect consumers. Or maybe they were being more, you could put it another way, they were being more friendly to the debt collection industry. And this rule simply is aimed at third-party debt collectors. So it's not aimed directly at my clients, credit unions. It's aimed at third parties they hire to collect their debts. And the same would be true for banks or other lenders. So there was a lot of public comments given by these consumer advocates. And the question is going to be, what weight do those have when the CFPB issues their final ruling? In some cases, the CFPB in the past has issued a proposed rule that has significant changes from the, or issues a final rule that has significant changes from the proposed rule. And in this case, we'll just have to wait and see how much the final rule deviates from the original rule.
So what concerns you under the proposed rule?
As I just said, while the proposed rule is directed towards third parties, not directed directly to my clients, it has the potential for establishing what would be considered fair and legal behavior, if I can say it that way, in collecting a debt. And the question becomes, are those rules then going to be interpreted by courts as how all creditors should act? Certainly you're going to have plaintiffs' lawyers who look at these rules and try to find ways to sue credit unions, banks, creditors. You know, a lot of these lawyers are looking for a way to make a living. They make a living from suing banks, credit unions, lawyers, who, you know, they're looking for opportunities. And this law could provide those opportunities. So while it doesn't directly impact our clients, it could indirectly impact our clients, and our clients are going to have to be aware of how these rules impact what they're doing, and may, even though it doesn't directly affect them, it may result in changes they need to make in their practices. So my concern is that credit unions are going to ignore this rule and not pay attention to what's happening, and fall in the trap of a potential lawsuit down the road.
So can you give an example of how the rule could become a model and how a credit union is supposed to act?
Yes, there are several, but I think one good one is the use of emails. So part of what this rule does is direct or regulate how a debt collector communicates with a consumer. So there are limits on the number of phone calls you can make, for example, in a week, things like that. But one of the things that it addresses with regards to email is the use of what would be a work email address. You know, so you think about somebody who works for, let's say, the state of Florida. Right now, there's nothing that specifically outlaws a creditor or a debt collector from sending an email to a person's work email about a debt. This new regulation would outlaw or make it improper to send a work email, to send a collection email to a work email address, except in certain limited circumstances, i.e. where the consumer gives consent. So if the consumer says, hey, email me at my work email, you're okay. But otherwise, you should only be emailing them at personal emails, like their Gmail account, those types of things. After this rule goes into effect, is that going to cause the argument to be you can't communicate with a debtor about their debt at their work email. That's the issue, and that's the question that comes into play. And these are the things that my clients need to be aware of, and what we're trying to stay on top of for them.
I mean, is it possible that then your clients could get sued by the debtors for breaking that rule?
Oh yes, that's the concern. Yep.
So that could cost them a lot of money. So I can see, I'm just bringing us here full circle. You're saving your clients a lot of money by helping them, figure out how to navigate through these new rules as they are, are allowed and are brought into real laws. Right now, they don't have to worry about it. So that's good.
Yeah. Our goal is always to save them money and to save it on the front end and avoid the lawsuits, as opposed to have to defend them in court, because lawsuits are expensive, as you indicated. And the old saying, an ounce of prevention is worth a pound of cure. That's what we're trying to do here. Spend a little bit now to save potential impacts later.
That makes a lot of sense, because you don't know how big those impacts can be, especially if they mistakenly don't turn off the communication going to work, and they've just got hundreds of creditors that they're trying to get in contact with. That could just be massive lawsuits and money spent. So I'm glad they have you. If credit unions do want more information or need assistance with these issues, what can you suggest?
One, I would suggest, certainly at any point, reach out to one of the lawyers in our firm. We're more than happy to answer the questions, review and your procedures, help you revise procedures, all as part of that maintenance that we talked about. We're trying to be preventative maintenance on the front end, so we can help with that. In addition, we have an upcoming webinar that we are doing that's going to touch more in depth on some of these regulatory issues. If you're interested, you can go ahead and contact me directly. That is, my email address is jim@svllaw.com, or you can go to the website and there's information there under our news section. And then third, if you're not a subscriber to our newsletter, to our email list, go ahead and go to our website and subscribe. That way you're sure to get any announcements, any information we send out whenever there is information that is related to credit unions and debt collection. We try to keep our clients informed. So when the CFPB issues its final debt collection rule, we'll be sending out an analysis of that to everybody who's on our email list. So those are all ways to stay informed and ways we can help them.
And not to mention interviews like these. You do these a couple times a month, and really have been able to keep people up to date on all the changes happening in the industry.
Yes, and we're thankful to be able to do these interviews to hopefully educate our clients and keep them up to date on what's happening.
Well, I love doing them with you, and I know how much your work means to your clients. And I'm just really so happy that you guys are really out there staying informed on their behalf. Whether it's taking extra educational classes, whether it's just keeping up on what's happening, even during a pandemic, and during all the abnormal stresses that everyone's going through, you are still keeping your eye on the ball, and that's really what you're there for. You're kind of a watchdog for them on what's coming up, what to watch out for to help save them money in the long run, and keep them in the black. I think that's great.
Thank you, Erica. Enjoyed talking with you today.
Thank you so much for being on. I'll talk to you soon.